The 1C Story Network, for the love of stories.
Live from the Sugden Community Theater on 5th Avenue South in Naples, Florida, this is What Do You Think?, where we vet the debaters and you decide who wins. Tonight's question, should internet media companies be liable for the content shared on their platforms? Now, here's your moderator for the evening, Frank Cipolla.
Good evening and welcome to the inaugural episode of What Do You Think?, a debate show where we vet the debaters and you decide who wins. Now, if you're looking for a show where people yell and talk over each other, you want to keep on scrolling. If you're looking to hear solid information, critical thinking, and civil discourse so that you can form opinions worth having, then you've found the right spot. Let me first start with the ground rules. Our debaters have provided sources for all of their information, and we've provided links to those sources for those of you watching via the What Do You Think YouTube channel. You can also find the links at whatdoyouthinkshow.com. If information is given out that we do not currently have the sources for, our in-studio fact finders will get to work finding a source and adding it online. These fact finders are librarians who hold master's degrees in information science and library science. If anyone could find information, it's a librarian. Second, the debaters. To debate on this show, certain educational and experience requirements must be met. We all have opinions, and there are plenty of us who can and do argue them. But here at What Do You Think?, we give preference to people who have devoted years toward education and work in the field that is being debated. That's because the purpose here is to cut through the personalities and volume and get to what really matters when you form an opinion: information. Third, the vote. I'm here in the studio with an audience of about 50 people or so. Both they and you watching online will be asked to vote. There are only two options, yes or no. Voting begins in the final few minutes of this episode. Online, you'll go to whatdoyouthinkshow.com to vote. Here in the studio, you'll circle on this particular card here, yes or no, put it in a hat as it's passed around, and then in our last few seconds together tonight, I'll announce the voting results of both the in-studio and online audiences. Now that you know what we're doing here tonight, let's get to it. Tonight's debate question is, should internet media be liable for the content shared on their platforms? Presenting the argument for the yes vote tonight is attorney Carrie Goldberg. She is the founder of C.A. Goldberg, a victims' rights law firm, leading the nation in landmark cases challenging legal immunity against big tech. As lead counsel in Herrick v. Grinder, Carrie introduced the novel legal approach of applying product liability law to tech products. The firm currently represents 28 families suing Amazon for selling a suicide poison to their children. In 2023, a settlement, AM v. Omegale, resulted in that platform shutting down. In 2024, the firm again overcame legal immunity in Neville et al. V. Snap for Snap's role in fentanyl deaths. The firm also represented the plaintiff in Doe v. Grinder relating to the foreseeable child rapes caused from the app marketing to children. Carrie served on the plaintiff steering committee in a case against Snap, Google, TikTok, and Meta regarding the platforms designing products intended to addict children. She has testified 4 times before Congress, helped launch the White House task force to address online harassment and abuse, and co-authored the 2024 Youth Poisoning Protection Act to ban the household sale of a suicide chemical. Carrie's legislative and litigation work for victims of image-based abuse is featured in the documentary Netizens, and her work has been profiled in New Yorker Magazine, Elle, Cosmo, Wired, Glamour, and more. Carrie is the author of Nobody's Victim, Fighting Psychos, Stalkers, Pervs, and Trolls, and Paramount TV is also developing a fictionalized series about Carrie and the firm. Please help me welcome Carrie Goldberg. Presenting the argument for no tonight is Ashken Kazarian. She is a senior legal fellow at the Future of Free Speech at Vanderbilt University, a renowned expert in First Amendment law and technology policy. She specializes in digital free speech, artificial intelligence, and the intersection of constitutional rights with emerging technologies. She has served as lead for North and Latin America on the content regulation team at Meta, where she also served as the company's policy lead on Section 230. She has been a senior fellow at Stand Together and the director of civil liberties at Tech Freedom. In addition to her work at Vanderbilt, she is a fellow for the First Amendment at the Freedom Forum. Ashken earned her specialist in law degree, summa cum laude, from Moscow State University. In 2012, she received a Master of Law degree from Yale Law School. During her time at Yale, she also contributed as articles editor for the Yale Journal of Law and Feminism, as senior editor for the Yale Law and Policy Review, and editor for the Yale Journal of Law and Technology, while also serving as co-chair of the Public Interest Fellowship. A sought-after commentator, Ashken's insights have been featured across major media outlets. She frequently shares her expertise on television, radio, podcast, in print, and in digital publications, shaping conversations on the future of free speech technology policy. Please welcome Ashken Kazarian. Okay, debaters, I'm going to flip a coin here, and hopefully I won't drop it, but here we go. We'll decide who goes first tonight on this. Heads is Ms. Goldberg starts first. Tails, Ms. Kazarian goes first. So it's tails. We're going to flip it right now, see what goes on. It is tails. Okay, so Ms. Kazarian, you give your first argument for why we should vote no to the question, should internet media be responsible for the content shared on their platforms?
Thank you so much. That's the first time I won a coin flip, by the way. Thank you so much, everyone, for being here. I think that if you're here, that means you care about freedom of speech online, because that's what's at stake if you vote yes. If you vote no, which is my position, we can save the freedom of speech online. And here is why this is a very complicated system that I need you to walk with me through. So the freedom of speech online boomed in the mid-90s. That's when internet platforms started being created, mostly in the United States of America. What also started happening was a bunch of lawsuits. These platforms were being sued. One of them was found to be not liable for user speech on that platform because they weren't moderating. They were having the see no evil, hear no evil, say no evil, get no liability kind of deal. But then, if a platform was trying to make Prodigy, was trying to make their platform safe for families, they were held liable for what people were saying on that platform. By the way, it was the Wolf of Wall Street. People from Wolf of Wall Street sued them. I digress. What ended up happening was a Democrat and a Republican saw that this was a wrong incentive. We wanted platforms to let more speech be online. We wanted them to moderate however they see fit and create different, diverse online communities. Chris Cox and Ron Wyden wrote what now we call Section 230, the law that created the internet. It's also the most misunderstood law, in my opinion, in America. It's been called the reason for every single harm that you experience online. I kind of think of it, I saw Wicked last week, kind of think of it as a wicked witch of the West. Everyone blames it for all the horrible things that people are doing in the kingdom. But she's working to make us, leave us be better for good. So we're going to get into what Section 230 does and doesn't, and Carrie and I don't agree on that. But I want you to take away this. The United States of America has a very litigious system. I'm a lawyer, Carrie's a lawyer. There's a lot of lawyers here. It's much easier to sue in the United States than anywhere else. In Europe, in UK, loser pays. And also, it's much harder to even get standing in court. That's not the case here. If you open the floodgates and let people sue platforms for anything controversial, they will moderate more and more. So your post on Nextdoor, your hikes on All Trails, your reviews of food on Yelp, Reddit communities for people struggling with health issues or people who are suffering pregnancy loss, who are trying to create supports for each other, that all will be gone. So we're going to talk about all the details of this, but that's my pitch for you. Please vote no.
We agree. bring up some very good points there, so we thank you very much. Now it's your turn, Carrie Goldberg, to take it from here and let us know what you think.
Well, first of all, I do not think that freedom of speech is at stake. How's this? Great. Okay. First of all, I do not think that freedom of speech is at stake. Section 230 is not the First Amendment. The First Amendment lived and breathed and had its glory days before computers were even invented, much less the internet. Even the most stalwart First Amendment lawyers, shout out to my husband in the audience, will not say that the First Amendment alleviates responsibility for all speech. If you lie, you're going to be subject to defamation. You don't get to say that it's the First Amendment right to threaten, I'm going to shoot you. And if you extort, that's not your First Amendment right. We're not seeking to create some new unprotected speech. Everything protected before the internet, I want protected after the internet. But I want the companies that make money. I want. Can I use your mic?
There you go.
I want the companies that make money from knowingly harming people to be responsible. And platforms censor speech all the time. When a politician calls and tells them to take down information that they don't like, platforms buckle to it. They engage in censorship. It's just for their own purposes. They have total discretion. Amazon will keep up child sex dolls, but if Amazon doesn't like a review from a mom saying a chemical killed its kid, they'll actually ban that parent from ever leaving a review again. But now I would like to move on to why you all should vote yes to companies being responsible for third-party content. And it's because bad companies owe their victims. I want you to imagine this. A 13-year-old is in the trunk of a car. She's bound, she's gagged.
Okay, I think your time has run out.
Oh, no, this is the rebuttal.
Okay.
Okay. This is why you should vote yes. 13-year-old is in the trunk of a car, barreling toward the US-Canada border. She's bound, she's gagged, it's dark, she's crying. How did we get here? Her trip to the trunk began a year prior when she downloaded an app. The app markets itself to children and says it's a safe space to make music with strangers. It provides private rooms to video chat. This child downloaded it without her parents' permission. They didn't know about it. No permission or parental controls were involved. The police found on the phone that she'd left behind that she'd been in intense communications with a man whose username on this app was Pedo for You. And he'd published music. One song was called B flat in A minor. Get it? B flat in a minor. The police found that he was exchanging child pornography. Now, this is not a hypothetical. For 12 years, I've been fighting against tech companies that catastrophically injure people. My clients are hurt, groomed, trafficked, harassed, raped, and sometimes die. This is not a policy or abstract issue to me. It's every single day. And I try to sue them to make them responsible and pay for what they've done to my clients. In my world, filing a lawsuit is the great equalizer. For the cost of an index number, somebody without a penny to their name can hold the most rich person or company liable. And since we can't arrest companies, this is how we hold them responsible. Unless you're a company that makes your money off of third parties, like the tech industry. My client was found 8 days later alive, but she suffered ungodly abuse with real costs. Both parents had to stop working. She was suicidal. She was in and out of outpatient and inpatient clinics. And her traumatized sister was even worse. The man was sentenced to 50 years, but the app marketed itself to children. It provided live streaming spaces, let people exchange child pornography. And it says it's immune from liability and was merely a passive publisher. Courts throw out cases like this all the time. But can you imagine leaving this audience today and there's a drunk driver on the street that says it's immune from liability and can just crash into you. That's basically what's happening with the tech industry. All other industries are liable.
I'm going to take that microphone and hand it over to Ms. Kasarian.
Thank you so much. Wait, is this working? Yes? Okay, there we go. There are a few things, I guess we'll have more time for free debate, but the main one I want to say is, first of all, I'm so grateful that there are people like Harry who are fighting for these victims, and they deserve justice and they deserve fairness. A lot of the victims they're able to sue the perpetrators. They end up in prison, they end up in jail. If websites in any way, shape, or form are helping commit this criminal act, Section 230 does not protect them. And there are examples of this. There's Backpage. Its executives went to jail because they were helping create tools that were part of the criminal liability there. There is, I believe, Silk Road, where they were selling drugs, right? They all end up being liable. What's important here that I think we're missing as part of the solution is actually that tech companies that are just creating these tools for us to connect with each other, they do report to NCMEC, which is National Center for Missing and Exploited Children. So last year, NCMEC got, in 2024, 20 million tips. 13 million of them came from Meta. They don't have enough resources to investigate. They don't have enough money. They don't have enough training. In general, police, FBI, they're not focusing on this enough. Imagine 13 million 911 calls not answered. Shouldn't we start by putting those who are responsible in jail, by going after these horrible humans? And if it's a platform that helped and contributed to this, they're liable too. Section 230 doesn't protect them. Section 230 protects platforms when they just design ways for us to connect. And also, let's say they have a tool where you just connect with someone and you create music. By itself, there is no harm in it. The harm comes from the bad actors who use it.
Okay, you can keep your microphone.
Okay.
We have rectified the microphone problems, and it is your turn to stand by while we do a quick commercial break. So let's take a quick break. While our in-studio and online audiences submit questions for the next round, we will be right back.
Change. Woo. Saying goodbye to someone you love, being a parent to your parent, changing jobs, ending careers, starting careers, death, divorce. None of us gets out of here without experiencing a significant amount of change. So what if change was more about possibility and less about problems? In 35 years of navigating change with my clients, with helping them with their assets, with their emotions, there's absolutely 100% something that I can tell you with all certainty. And that is your response to change has everything to do with its effect in your life. You're in control more than you think that you are. Change is about choice. And because I don't have more than 24 hours in a day and I can't sit with everyone, well, I wrote it all down. Change in my pocket is what I've learned up to now. And it's available to you in bookstores nationwide. And if it's easier for you, we've got ebook and audiobook as well. Change doesn't have to be about devastation. It can be about liberation.
Welcome back to What Do You Think?, where we vet the debaters and you decide who wins. Tonight, Carrie Goldberg and Ms. Karazan is discussing this. We have a question from the audience, and I have it right in my hand right here. Is what do platforms suggest we do if not insisting on guardrails? So we're going to start with Ms. Goldberg first on this. Why don't you tackle this? We're switching microphones again. Go ahead, take a shot at it.
Can you reread?
What do platforms suggest we do if not insisting on guardrails?
Platforms don't want us to do anything different. This is a gravy train for them. They get to mint money off of us and never experience a day of liability. Car manufacturers are responsible if the brakes go out. Boeing is responsible if the door flies off an airplane mid-flight. But the tech industry, it's the only industry in this country that has no liability for the people that it hurts. Even the gun industry, they're liable for their marketing and for product defects. The app I was talking about earlier, it chose to lure kids and have private spaces for adults and children to engage. It chose to turn a blind eye to the child pornography it was hosting. It was no coincidence that somebody got hurt. Platforms don't want regulation. They don't self-regulate, even when they're providing information to the National Center for Missing and Exploited Children, like Ash mentioned. That's one of the only laws that actually they have to comply with, 18 U.S.C. 2258. They have no incentive to change.
Okay.
To answer your question, big tech actually has endorsed Section 234. Meta has endorsed Section 234. Mark Zuckerberg, in a hearing, did in 2022, I believe. They are okay. They can survive the swift lawsuits that are coming. And also, they will just get rid of a bunch of user speech that's controversial. What is healthy body image is controversial and can be sued over. Meta, first of all, cost of litigation is so high. Meta can survive it, but it's still easier for them to get rid of any kind of speech that they don't like. The platforms will turn into something like Netflix, where they just choose what to show you, and you don't get user-to-user interaction. That will be gone. Section 230, and why I'm fighting for it, is because it protects user speech and our communities that let us connect to each other. If platforms are doing what Carrie was talking about, where they're luring children, we should call FBI. I don't know if they're busy right now, but if they are doing that on purpose, that is very much out of scope of Section 230 from what I know. I also think we need, and we still don't have, a federal privacy law. Now, I'm not the one who would draft it, I'm a free speech lawyer, but we need to be better about our data online. I'm obviously more comfortable regulating data and making sure our data is safe, both from the government and from big tech, than I am regulating speech. Because once again, big tech, they don't care. They're going to over-censor, they're going to over-moderate, and they're going to be the incumbents who stay the same, while startups and smaller platforms that are growing, that are challenging their position, won't be able to withstand the cost of lawsuits, and they would go away. So Section 230 is here for Wikipedia. Section 230 is here for my favorite app, Belly, where you can post the food you're eating at restaurants. And it's here for people to organize. Without Section 230, Me Too movement that started on Twitter wouldn't be possible. Without Section 230, Black Lives Matter movement wouldn't be possible. Section 230 also defended, speaking of guns, Arms List, website where you can sell guns, I believe, in Wisconsin. Section 230 applies equally to any type of speech, whether you agree with it or not.
Okay, you can keep your microphone, I think. Oh, actually, we have to transfer the microphone to you. All righty. Your rebuttal.
So another reason why you should vote yes is because it's your right to sue. Litigation improves safety and innovation. Platforms are products. They're engineered, designed, they're marketed. Companies like Meta, Google, Amazon, they run the most sophisticated algorithms in AI. Lawsuits brought by hurt people are a driving force in safety. It's because of lawsuits that we have airbags, safer cribs, flame-retardant pajamas, lead-free paint. Now imagine an industry that developed outside of safety, an industry that distributes products into everyone's hands, provides portals into a whole nother world in every child's bedroom. Imposing liability doesn't stifle innovation. It would actually have incentivized companies to offer safer products from the get-go. Founders would have had to ask, how could this have been misused? What are the predictable harms from this? Now, I've personally observed the safety innovations from my own successful cases. Omegle increased its age for users from 13 to 18 before shuttering altogether. Amazon finally stopped selling suicide kits after I sued them enough times. Meta added protective default settings for teens. Meanwhile, platforms without liability have just been spiraling down. Match Group recommended a cardiologist to dozens of women in the Denver area who then drugged and raped them. I represent 6 of the victims, and Match Group knew that he was using Tinder and Hinge for 2 years while he was continuing to access women. Discord continued to host the child mutilation cult 764 several years even after its founder was arrested. Sanctioned Suicide, which had gotten kicked off of Reddit and 8chan before starting its independent site, has helped thousands of young people die. The threat of litigation, it makes companies prioritize safety over profit. The lack of that pressure has enabled the tech industry to run amok. Unlike Europe, with its regulatory system, in the US, we expect companies to self-regulate and to not harm. And the civil justice system is for injured people to get justice. It may not be a perfect system, but it's the one we have. And our government stays hands-off because of it. We need the right to be able to sue when we've been injured.
Ms. Kazarian.
Thank you. We do have a right to sue the perpetrator. We do have a right to sue those who have injured us. What happens here is that if you sue platforms for a specific type of speech, they're just going to get rid of that speech. We actually have an example of what happens where Section 230 is not there. The only time it was amended was in 2018. It was this law called FOSTA SESTA. And the goal was to target people who were sex trafficking online. SESTA FOSTA, since it's been, at least in 2021, so 3 years later, had been used criminally only once. But what happened was, because platforms were so worried about liability, and they didn't want to, again, the scale is great. There are thousands of posts that go up every day on each platform. So because platforms didn't want to get sued, huge parts of their communities were shut down. Reddit shut down communities for sex workers, and this is not a debate about sex work, but sex workers were using platforms to keep each other safe, to share information. Their income went down. They had to go back into the streets. SESTA FOSTA, the one amendment to 230 we've had so far, didn't put more people behind the bars, but it did get rid of parts of Craigslist, like parts of the internet just went away. Because again, platforms are not good or evil, although I do think they're evil most of the time. But they do act in self-interest, and they will shut down parts of anything that they can get sued over. And we will be left with maybe only cat videos or dog videos, which maybe that is the society we want. But I do want to have a society where I can connect with other users and have a community, and that will be gone too. Oh, is it me? Yeah, okay. It's me again. Hello. So let's talk about litigation. Carrie was talking about seatbelts and planes and Boeing. Did you talk about Boeing? Yeah. There's a big difference between platforms and cars and planes, and that is that platforms deal with user speech. That's the main difference. Every time they make a decision, let's say an algorithm, right, makes a decision to prioritize specific speech and deprioritize different type of speech, it's a decision about speech. The Supreme Court last year in Choice v. Moody has said that it's part of their editorial discretion using these algorithms and ranking speech. So it is their First Amendment right to do so. That's what differentiates them from all the other torts. And I know you do a lot of tort litigation, but you have won some cases where it wasn't about speech, right? Your theory, very innovative one, was at the center of Lemon v. Snap, right? Where it was a speed filter on Snapchat that teens were using, and they got into a horrific accident and all passed away. Snapchat was held liable because in that case, it wasn't about speech, it was about product that was defective. So Section 230 doesn't stop lawsuits from defective products. It stops lawsuits from, let's say, a politically motivated actor. Someone who is anti-insert political debate of the day, they will sue platforms to get rid of it. Let's say it's a pro-life or pro-choice community online, it would be gone. Or a religious community, or a community for victims of abuse. The other party can sue, and platforms is not gonna, again, they're not here for our interests. Section 230 protects users, not the other way around.
Okay. I am the mic transfer. Here you go.
Okay, so we don't sue perpetrators. We don't sue the individuals because they're in jail. Now, one of the main concepts of civil justice is that if somebody's hurt you, then somebody needs to pay. And so if a company is knowingly injuring you, then, and letting, like, it's so foreseeable that you're going to be hurt by some misuse of the product, then that company shouldn't get off the hook. And suing a judgment-proof perpetrator isn't going to help my client who's been abducted and is tied up in the backseat of the car. And it would be nice if Section 230 only did limit speech, but it doesn't. I've probably lost more cases when it comes to Section 230 than anybody in this country. I don't want our fact checkers to fact check that, but I've won a few. And I will tell you that my claims are the same. I sued Grindr for the exact same claims I sued Omegle for. When Grindr was marketing to children, it was advertising on TikTok and Instagram using gay children in high school settings and cafeterias to try to get more kids to use its app, which, by the way, is supposed to be for 18 and up. And then it was telling new users, hey, you have to be 18 to use this. How old are you? My client, a 15-year-old kid with autism, downloads Grindr, and over 4 days, he's raped by 4 different men, all of who are nearby, all of whom Grindr has recommended him to. I used the exact same claims as in the Omegle case, and suing it as a product that was defective, and it was still thrown out.
Okay, free debate. And we'll do the microphone transfer again.
So let's talk about design choices in Grindr, which I think they as a company should do better. These are choices about how people are communicating with each other. So every communication tool can be used for harm. Phone calls for scams, email forwarding feature, you can forward phishing emails. They all can be used for harm. They're tools. Which design choices in this Grindr situation? Geolocation matching, that's what Uber uses, that's what Nextdoor uses, that's what that app Belly that I talked about, that's my favorite, uses. And also, should we then hold platforms liable if minors lie to them and tell them they are 18? So should platforms be held liable for lying, for their users lying to them? And then do we want them to monitor all of our messages, to monitor all of our internal communications? That's what I don't want. I don't want platforms to snoop and look through everything. Also the question of knowledge, right? this, again, comes back to the scale of the internet. And I'm not saying we shouldn't hold platforms' feet to the fire and demand they do better. But even if they hired everyone who uses the platforms, and this is a hypothetical, I don't know if you can fact check this, but even if they hired everyone who uses the platforms to moderate what's going on the platforms, the scale would be so great that it wouldn't be enough. And so they're always going to mess up. And if we hold them liable for each time, I'm sure they would get like a bazillion messages every day that this is going on, this is going on. What would be your criteria of they now have knowledge that this is happening?
Well, if somebody tells them it's happening, or, in my case against Amazon, when Congress has told them that they're selling a suicide kit, and I've told them, and they're being sued for it, and there's journalism about it, and all these parents of dead kids are leaving reviews for other parents saying, this product killed my kid, and Amazon, instead of stopping selling that product, it instead removed the comments from the parents and punished the parents and said that they were losing their ability to ever leave a review again. And Amazon says that is it's Section 230 right. But, notice is an interesting thing, but it's also like they're getting notice, and they're not doing anything about it. They have to be sued in order to actually reform themselves. And it's also litigation is exposing what's happening. The discovery process has actually made it so that we know that Meta has to be told 17 times before it will actually remove a trafficker's profile. So, what do you say to that when they know about these harms that are consistently happening on their platforms?
So I did not read I read a lot of your cases, incredible work. I did not read the Amazon case. To me, it sounds like that would be a product liability, not 230. But again, I would have to look at the case. But it doesn't sound to me like it's choices about speech. Now, about notice. We all know you. We know your work. Maybe if you notify them, you should be their trusted notifier, and they should take it down. But again, with the scale, what if a perpetrator is notifying Meta that on Instagram, their victim is exposing the perpetrator, and Meta just takes it down because they're not going to go into investigation over what the case was about. They're just going to keep taking down speech not to be liable.
Okay, why don't you hold on to that for just a moment. Folks, we're going to take a quick break here. A reminder, while you're watching online, drop more questions into those comment sections, and we'll be right back.
Check, check, 1, 2, check, check. Check, check, 1, 2, check, 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 1, 2, check, 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 check.
Check, check, check.
Still not. Okay. All right, we're back. The beauty of a live broadcast, as it were. All right, you're back to What Do You Think?, where Carrie Goldberg and Ashken Kazarian are debating the internet media company liability. And we have a lot of questions. We also have questions from the audience. I think we also have a question online at this moment, or a question from the audience. Somebody could give it to me. All right, here we go. This is the story that comes out. Thank you, sir. Let's discuss, please, redefining Section 230. After all these years, does Section 230 need to be refined? Okay? Let's start with you.
Well, I don't think it should be, so I think you should go first.
Okay,
right?
why don't you go first?
Oh, Section 230 should be refined, that's the question?
All right, yes. Should Section 230 be redefined?
Redefined. Oh, actually, I have a mic now. Okay, so I'm a civil litigator. I don't want to regulate everything. I want to basically let companies be free to be who they are and for the civil litigation system to take care of it. So if somebody's injured, then they should have every right to go after a company that knowingly profited off of that person's injury and they were harmed because of something that was foreseeable. I don't think the solution is to redefine Section 230. I don't necessarily feel that Section 230 needs to be thrown out. I'm okay with actual words, somebody calling somebody else a bitch on Twitter or X. I'm okay with Twitter not being responsible for that kind of speech. Our civil litigation should be taking care of situations where a product is defective, but it doesn't. I have as many cases thrown out because of product defects and they're not speech-based. And these companies are the first to say that the defective people are the ones using their product, even the people that they know about.
So what is the defect, what is the defect of Grindr geolocation feature?
Well, it's really, if it's a product that is marketing to children and luring children, and then that child is matched with a nearby predator, then that's a defect. Especially in my client's case, he downloaded Grindr at school. There was no geofencing. But the core of that case was really the marketing to children.
Wouldn't that be a privacy claim? I don't think this is speech-based.
But how would I sue Grindr for privacy? That's not a tort.
Well, okay. Thank you for answering that. I think when it comes to questions around torts, which is welcome everyone to Law School 101, that's the first thing, usually it's the first year that you study it. It still is a question of, well, what are you suing over? And if you do we get rid of, okay, so geolocation Grindr is using, and I don't know, I haven't seen that they were marketing to, I believe they did maybe. But then, does that mean then Uber is responsible for geolocation, Nextdoor is responsible for geolocation feature? Do we just then get rid of all of that? What design features are then left? Do we just get a chronological feed and that's the rest of the internet? Also, I appreciate you conceding that Section 230 should still protect speech, but I think that leaves out, are you okay with it just being only on defamation, or do you want to go for, you said you don't want to repeal it, so what's the line?
Well, I think I first want to get back to something that you just said,
Okay.
Which was about the geolocation. Because the features themselves have to be put into context. So if you run the world's biggest hookup app that is based on matching strangers for sex, and then you're marketing it to children, then the entire product is defective. And the geolocation is something that is enabling the matching, but it's not, taken without context, that's not what I'm talking about. And in my litigation, there's the whole host of defects. It's the marketing to children that's at core.
So in the facts of your case, when they were marketing, they were choosing to market to 18 and younger. You have that piece in there?
Yeah, on TikTok and Instagram.
But just on TikTok, or they were choosing the ad feature that was going to be, we only want this to be.
All right, let's hold on a second. We're in the free debate section now, which we've been pretty much doing over the last couple of minutes because I wanted to hear this, and I'm sure the audience as well. But you have about 4 minutes, so you can free debate on this particular question.
Okay. I want to know who helps my client in this situation. My client who was raped by 4 different strangers over 4 days. My client who's in the trunk of a car because of an app that she downloaded and matched her with strangers that knew child pornography was being exchanged. what happens to those people? I mean, the actual perpetrators, they're in jail. Like, how does my client get money for therapy if she can't hold these apps responsible?
Can't you civilly sue the perpetrators?
Somebody who's in jail with $0 and 0 cents.
Oh, so
that's
this is
making
about
50
platforms having bit deeper pockets.
Absolutely. If somebody hurt you, they should pay. And these companies.
But it wasn't the companies, it was the perpetrators who hurt them.
Well, the companies made it so that it was almost an arithmetic certainty that somebody was going to get hurt. If you have a platform that knows that child pornography is being exchanged, then.
Child pornography
and you're
is
matching children to adults.
Child pornography, CSAM, is exempt from Section 230 protections. You can, if a platform knows there's CSAM going on in the platform, they're liable.
What law? Give me the section, because it's not exempt from Section 230.
I don't know the section, but maybe our fact checkers can find it.
They won't be able to.
CSAM is illegal.
It's criminally illegal, but you can't sue a product for exchange. I mean, Meta, when you're actually in like a rare moment of transparency, reported that they'd had 60 million images of CSAM go viral, or be exchanged. Sorry, I didn't mean to say go viral. No one can sue them for that.
But they were not the ones who created that, and they reported it to NCMEC.
Right, but that's not what you just said. You said people who are the victims of CSAM can sue. Like that Section 230 doesn't have liability.
They can sue a platform that is like on purpose doing this.
Like if Mark Zuckerberg was taking naked images of children and posting them, then yes, you could sue Mark Zuckerberg for that. But I mean, even Omegle, like, which was matching strangers for live streams and interactions, and I mean, it was basically attractive to kids at sleepovers and adult predators, and you could not go on that app without seeing naked people if you were a child or an adult. Even that case, like, Omegle was not responsible for the actual content.
But you prevailed in that case on other claims, right? What were those claims?
It was the product liability, the same claims that often fail.
But you won that case. You're bringing
Hooray.
it up, but like.
Hooray, but because of Section 230, there's absolutely no predictability if a case is going to succeed, like Omegle did.
So you want to win each time?
Oh, yeah. I want there, I mean, in all other forms of personal injury, you know, like there's not the same threat. Like there's some sort of certainty that you're going to be able to prove your case, that you're going to get in front of a jury if you have the claims and the facts that support them.
Platforms would just get rid of so much speech if that was the case, if they could get sued over and over again. And the small platforms would stop existing because they wouldn't be able to bury the cost of litigation. Engine did some research, Engine.org, they did this research about how much it would cost. It's between $100,000 and $500,000 to just go to court and prove that they didn't do anything wrong. All the startups will go away and all the big tech will stay.
All right, we have about 30 seconds for final thoughts, so keep it really short, 15 seconds. We'll start with you, Carrie.
The key is to not do harm. If you're not doing harm, then you're not going to get sued. I run a business myself, and I run it like trying not to harm people, and therefore I am not getting sued all the time.
The internet is more of a mirror to our society. It's showing us all the horrible and bad people who exist there. But if we get rid of Section 230, which I don't think Carrie wants to do either, that's what she said. But if we do, because that's the question here is, should platforms be liable for what other people say on those platforms? Then vast majority of speech would be gone. I know it sounds like a chapter from 1984, but that's what would happen because the cost of litigation and platforms wanting to avoid risk were going to go there. The internet, as we know it, would be dead.
All right, ladies, thank you very much. Now it's your turn. To hear what you heard and vote accordingly. You've heard some solid information from reliable sources. It's time to tell us what you think. Should internet media companies be liable for the content shared on their platforms? Throughout the next commercial break, the voting is open at vote.com. It's open to vote at what do you think show.com. And please vote then and also in the audience, and we'll hear the results live coming up in just a moment.
Change. Whew. Saying goodbye to someone you love, being a parent to your parent, changing jobs, ending careers, starting careers, death, divorce. None of us gets out of here without experiencing a significant amount of change. So what if change was more about possibility and less about problems? In 35 years of navigating change with my clients, with helping them with their assets, with their emotions, there's absolutely 100% something that I can tell you with all certainty. And that is your response to change has everything to do with its effect in your life. You're in control more than you think that you are. Change is about choice. And because I don't have more than 24 hours in a day and I can't sit with everyone, well, I wrote it all down. Change in my pocket is what I've learned up to now. And it's available to you in bookstores nationwide. And if it's easier for you, we've got ebook and audiobook as well. Change doesn't have to be about devastation. It can be about liberation.
Before I announce the results.
Change. Whew. Saying goodbye to someone you love, being a parent to your parent, changing jobs, ending careers, starting careers, death, divorce. None of us gets out of here without experiencing a significant amount of change. So what if change was more about possibility and less about problems? In 35 years of navigating change with my clients, with helping them with their assets, with their emotions, there's absolutely 100% something that I can tell you with all certainty. And that is your response to change has everything to do with its effect in your life. You're in control more than you think that you are. Change is about choice. And because I don't have more than 24 hours in a day and I can't sit with everyone, well, I wrote it all down. Change in my pocket is what I've learned up to now. And it's available to you in bookstores nationwide. And if it's easier for you, we've got ebook and audiobook as well. Change doesn't have to be about devastation. It can be about liberation.
And welcome back to What Do You Think? Before I announce the results of tonight's in-studio and online votes, we want to thank these incredible women for taking the time to come to Naples, Florida, and share with us their experience and education in this field. You've taught us much tonight, and we thank you very much. Now, while I'm extending gratitude, Sherry Moxley, author of Change in My Pocket, your underwriting of a significant portion of tonight's episode created a bellwether for the return of critical thinking and civil discourse in American culture, and for that we thank you very much as well. We also want to thank Amy Turner, the Center for Critical Thinking, former Majority Leader Dick Gephardt, the Becca Schimmel Foundation, Openly Gray, Tim Love, John and Randy Brooklier, Michael Schrock, Dr. Margot and Mr. Terry Gottlieb, Robert McDonald, Jennifer Green, the Inn on Fifth, and Vote Common Good. Without all of your support and the participation of you, our viewers, this endeavor would not have been possible, nor would next year's episode. So thank you all again. You deserve a nice round of applause. All right, everybody, the time has come. We brought in the experts. They gave you information. And then we've asked you, should internet media companies be liable for the content shared on their platforms? And here in the studio, the majority of you voted yes. And watching online across YouTube, TikTok, Facebook, Twitch, and Instagram, you voted yes as well. So we thank you for watching. To our audience members, you're warmly invited to the reception at the library right after the show. And to those watching nationwide, thank you for being part of the inaugural episode of What Do You Think? Good night.
The One C Story Network.